Good afternoon, everyone. I'm very pleased for this opportunity to be here today. With your permission, I'll be a bit brief. I won't say everything I intended to because Professor Dienstein has addressed some of the issues I wanted to bring up. I'll talk about how armed conflicts between states and terrorist organizations are dealt with by international court. I must say that it doesn't always culminate into an armed conflict. In certain cases, a country can deal with terrorist threats through its law enforcement system, through examination and the arrest and prosecution of terrorists. In other cases, the scope of the terrorist activities is much smaller and doesn't reach armed conflict. So international law addresses these cases as well. But I chose to focus today on these cases in which the scope of violent acts reach a level that define it as an armed conflict. So an armed conflict between a country and a terrorist organization taking place outside the territory of the country, this is something which has developed over the past decades. Usually, countries use law enforcement measures in order to deal with threats coming from terrorist organizations operating outside the state. In extreme cases, the countries would take specific self-defense acts against terrorist organizations. But in the past few decades, conflicts between countries and terrorist organizations have evolved into an armed conflict. In addition to the examples already listed by Professor Dinstein, for example, Turkey's activities in northern Iraq and Israel's war in 1982 in Lebanon, there are some two other examples such as Morocco against the Sahrawis in Western Sahara, India, and the Tamils in the 1980s in Sri Lanka, battles between Rwanda forces and rebels from the Hutu tribe that were inside Congo. According to certain views, the U.S.'s war with Al-Qaeda, as well as our wars, Israel war against the Hezbollah, which took place in Lebanon, and the recent war in Gaza, which was between Israel and the Hamas. Not necessarily all ultimately fit the same category, but these are specific examples of conflicts between a country and a non-state entity outside the territory of the country, which is a party to the conflict. Without assuming to give an exhaustive explanation, I can mention two reasons which led to the enhancement of terrorist organizations and led to the need ultimately to operate against them outside the state's territory. First of all, when the 20th century, in the second half, the concept of a failed states has developed. Failed states in which the central regime has lost its monopoly over use of force, and these serve as a convenient basis for activities against terrorism. The central government cannot prevent the terrorist organization from operating, so they can have training bases there to accumulate weapons and to plan terrorist activities with no interruption. Other countries are more limited in their activities against this terrorist organization, because then they need to operate in another country's territory. Like Professor Dinstein explained, they are not completely unable to do so, but this does require operating in a foreign territory. Also, technology has changed. If in the past terrorist organization couldn't really risk countries from actions outside the territory, today they can risk the country with activities done outside the territory of the country. For example, launching missiles. Again, in such a case, ultimately, a certain action is required within the territory of the launching country. So, for our purposes, the important point is that when the central conventions and treaties, such as the Hague Treaty in 1907 and the Geneva Convention from 1949, in these periods, the phenomena of a war between a terrorist organization and a country was almost non-existent. Therefore, it is not surprising why these conventions did not try to regulate this issue. Well, then, the answer is clear. International law needs to deal with a new issue that has not been dealt with in the conventions, and not much practice has been accumulated as well. So how does international law address armed conflicts between countries and terrorist organizations which take place outside the country's territory? Of course, there's the question whether a military conflict outside of a certain country, between the country and a terrorist organization, should this be addressed as an armed conflict? I think it's important to distinguish between the question, when can the country operate with military means against the terrorist organizations, and the question, what law does apply on these military activities. I don't wish to focus on the first question, whether a country is allowed to take military measures against terrorist organizations. I think that even those who deal that law enforcement should be used with dealing with terrorist organizations, it will be difficult for them to say that Israel really cannot protect itself when a terrorist organization such as the Hezbollah launches on a daily basis rockets from Lebanon into Israel without the Lebanese government doing anything to stop them. Anyhow, Professor Dinstein has already wrote the ultimate statement in his book, in which he developed the doctrine of extraterritorial law enforcement, so that's very clear, and also Professor Dinstein has explained all that. So I would like to focus on the second question, what kind of set of laws should be applied in a situation in which a country takes military measures against a terrorist organization and the military conflict is relatively high intensity. I think there's broad consensus, at least amongst scholars in international law and also among countries. There's a broad consensus that this should be viewed as an armed conflict, and to apply the set of laws from international law which apply to international law, which are the laws of war. And even if you accept the approach that or a view that this is indeed an armed conflict, still the question is, what type of conflict is this? Traditionally, international law has recognized two types of armed conflicts: an international armed conflict, or more precisely, an interstate armed conflict, or a non-international armed conflict, or as it is called elsewhere in the literature, intrastate conflict. And it is acceptable to think that international armed conflict would be conflict between countries. For example, the Yom Kippur War or the Iran-Iraq War. And a classic example for a non-international conflict is a civil war. For example, the conflict in Sri Lanka. And the issue of classification is, of course, important because it determines which set of laws would apply on the conflict. Without getting into details, international law has placed many limitations on countries involved in international conflicts than countries that are involved in non-international countries. The reason being that quite a few countries saw civil wars as an internal domestic affair and refused to include in the conventions anything that would limit their fighting in this type of war. So if you accept these categories as point of departure for discussion, then an armed conflict with a terrorist organization which is outside the state actually doesn't fit any category, because on the one hand, this is not a conflict between countries, therefore it is not an international country, at least not in the classic sense of this term. Yet on the other hand, this is not a conflict which is limited to the boundaries of that country, such as a civil war. Therefore, it doesn't fit the classic definition or classic category of a non-international conflict. I suggested at a certain point that the way to deal with this difficulty is to recognize a new category of armed conflicts, which I called an extra-state armed conflict. And I think the lack of compatibility of these conflicts to the definitions of the two types of categories recognized in international law, international armed conflict and non-international armed conflict, is not just a formal matter of fitting the categories. Essentially, a conflict between a country and a terrorist organization includes elements which can be taken from both categories. On the one hand, it has an international aspect, the conflict, because it takes place outside of the territory of this state. Therefore, some of the arguments that led to reducing the limitation on non-international conflicts, for example, that it's only a domestic affair, do not apply. But on the other hand, this is a conflict against a non-state entity, and in this aspect, it is more similar to a non-state armed conflict or non-international. So I think we need to recognize a new category with interesting elements. Just like can be understood from what Professor Dinstein said, this suggestion did not receive broad support for the reasons mentioned by Professor Dinstein. The courts that needed to address this issue in the past few years had to classify armed conflicts within the existing categories and did not recognize the existence of a new category. For example, the American Supreme Court on the Hamdan case mentioned by Professor Dinstein decided not to decide on the definition of the conflict between U.S. and al-Qaeda. The situation the U.S. faced in Afghanistan is a bit different than what Israel faced in its war on Hamas or Hezbollah. The U.S. fought against two forces, the Taliban forces, which held the government in Afghanistan, and the al-Qaeda forces, which is a terrorist organization which operated in Afghanistan. Two approaches were presented to the U.S. Supreme Court. One was to see al-Qaeda as part of the Taliban and to classify the conflict as an international conflict, that the parties to this conflict are, on the one hand, the U.S., and on the other hand, Afghanistan. And the other option is to recognize two separate international conflicts, one with the Taliban, one with al-Qaeda, and to grapple with the question which law should be applied on the conflict between the U.S. and al-Qaeda. The U.S. Supreme Court decided that it doesn't have to choose between the two approaches. They said that Article 3 to the Geneva Convention, which regulates non-international armed conflict, applies to a conflict which is not between two countries, and the principles in it apply to all types of conflicts, because this Article 3 of the Geneva Convention was enough in order to solve this issue. It didn't see any need to decide on classifying this conflict. On the other hand, the Israeli Supreme Court, in a set of rulings, that one of them was on the subject of targeted killing, that the conflict between Israel and Palestinian terrorist organizations is an international armed conflict, and it relied on the position of Professor Cassessa, one of the leading scholars in international law, according to which armed conflict in occupied territory is an international armed conflict. But it adopted even a broader view than Professor Cassessa's, and it determined that any conflict that crosses the borders of the state, regardless of the question whether it is in occupied territory or not, is an international armed conflict. And it reiterated the opinion when it discussed Operation Cast Lead. And of course, this view is very different from the view of the American court taken on this principal question. So the bottom line, therefore, is that there's broad agreement in international law that laws of war do apply in armed conflicts between countries and terrorist organizations. The question which laws apply still hasn't been decided in international law. Some people claim that the rules which apply in international armed conflict need to apply, and others think that the rules that apply to non-international armed conflict should apply. Practically, it doesn't really matter. The overall trend today in the field of war laws is converging of the rules in international and non-international armed conflict categories. For example, the laws in international armed conflict regarding protecting civilians and choosing targets also apply to a non-international armed conflict. The main difference which still remains between these two sets of rules is the entitlement of a combatant to a status of prisoner of war. Prisoner of war status is awarded only in cases of international armed conflicts and not in non-international armed conflicts. So to conclude, international law gives countries significant tools to combat terrorism. International law recognizes the fact that in certain circumstances, a country can operate against a terrorist organization outside its territory. The scope of once this conflict crosses a certain threshold, then international law recognizes the existence of an armed conflict between the state and a terrorist organization. And in such a situation, the country might strike at different military targets and the combatants of this organization. It's important to say now that this development also raises complex questions. For example, in which circumstances can you operate against a terrorist organization in the territory of a different country? How do you decide that a certain organization is a terrorist organization? Aren't we giving countries too large a force to shift from law enforcement to a conflict, to an armed conflict? What to do when these terrorist organizations operate from within civilian settings? And I will suffice with raising the questions. Professor Dinstein has addressed some of the things, and I think we can address other issues which will interest you during the Q&A session. Thank you very much.